Okay, good afternoon, everybody. Welcome to INCOMPAS's Policy Summit 2021. I hope you all have been enjoying it as much as I have. It has been a wonderful series of sessions and discussions, and I've learned a lot in this time frame. It is really a truly exciting time to be in communications and to be dealing with the many broadband and other policy issues that are before the agencies. This panel is called Meeting the Mark, Robocall Compliance. It is actually one part of two parts that we're going to discuss today. We are lucky to have members of the FCC with us today to talk about robocall compliance and the FCC's robocall activities. After we do this discussion, we will have another discussion with industry members talking about the implementation of the FCC's robocall activities. So we have a lot for you today. I hope that you will be very active and let us know what you are interested in. You can provide us with questions using the Q&A function in the session. So please look down at the bottom of your screen. There's a Q&A function. Please type your questions in there, and we will do our best to answer them during the session itself. So with that, we're going to get started on the session itself here. I want to point out that over the past half decade, the FCC has, in its words, implemented a broad range of actions to combat illegal and unwanted robocalls. And with a particular focus, the FCC says, on giving consumers and carriers the tools necessary to block unwanted robocalls. And that has happened in a wide variety of different proceedings. These actions have included enforcement actions against known spoofers and robocallers, industry traceback efforts, and activities against voice service providers known to originate illegal calls. So there are certainly quite a lot of activities out there. We today are going to focus on two of the tools that the FCC has identified: call blocking and call authentication. I'm very pleased to have joining with me today Jerusha Burnett, who's an attorney in the Consumer and Government Affairs Bureau of the FCC. Jerusha, thanks for joining us.
Thank you for having me.
Yep. We also have CJ Ferraro, who's an attorney in the Wireline Competition Bureau. CJ, again, thanks for joining us. So we're going to begin on this. The FCC, as I said, has two principal activities that they have been focusing on in these areas here, on call blocking and then on call authentication. So we're going to start with the blocking side of this. And Jerusha, that's been in your area, and the Consumer and Government Affairs Bureau has kind of taken the lead on the blocking activities. So let's start with just kind of looking at where we are and how we got here. Beginning in 2017, provided carriers with authorization that was viewed as anathema to common carriage. That is, the ability to block certain types of calls. So that was really new and groundbreaking for the commission to go that route on there. Can you take us through really the major categories of calls that the FCC has said can be blocked by carriers?
Yeah, of course. I should note that the FCC had made some statements about blocking prior to 2017, primarily in the VoIP context, which of course is not as much the common carriage context, and generally only with consumer opt-in consent. So 2017, while a fairly dramatic point in time for the degree to which the commission has been going full force in call blocking, it was not necessarily the beginning of the commission's work there. But the 2017 call blocking order is the first big item here. So that order said that providers may block calls that are unassigned, from numbers that are unassigned, unallocated, or invalid. It also authorized blocking of calls purporting to originate from numbers where the subscriber to the number asks that the calls purporting to originate from that number be blocked. So this is your standard DNO scenario, do not originate. The best known example of this is the IRS inbound calling number case, where spoofers and scammers were trying to spoof the IRS's inbound only number, so that if a consumer Googled the number calling them, right, and looked up the number calling them, they got, this is the IRS. And so that when they answered the phone and the person on the other end said, you know, this is so-and-so from the IRS, the consumer was more likely to believe that call because the number matched up.
As it happened, they didn't actually originate calls with that number.
Right, yeah, it was an inbound only number, which is really, really, really important in the do not originate context. Do not originate only works for inbound only numbers, because if you place calls from that number, those calls are going to get blocked too. Right. So all of these categories, unassigned, unallocated, invalid, DNO, these are all categories the commission has said that providers can block without any consumer consent. They can just block them in the network, that's fine. And the reasoning the commission gave for that is that there's no really valid reason for any caller to be using these numbers. These are numbers that either no one has legitimate access to, or that the person who does have legitimate access to has said, hey, I don't use that number this way. So in reaching that decision, the commission said that no reasonable consumer is going to want a call that is highly likely to be illegal, and there's no valid reason for using these numbers, therefore they're highly likely to be illegal, so you can block them. That was the 2017 order. Then we move ahead a couple years to the 2019 call blocking declaratory ruling. And that built on a lot of the commission's prior statements that I was talking about sort of pre-2017. Those statements about offering call blocking and not violating call completion obligations because consumers themselves have the right to block calls. So I think it's fairly uncontroversial to say that if I take out my phone and say block this number, I should be, there's no reason to say I can't do that. So the declaratory ruling is basically saying consumers can designate their provider to do that for them. The declaratory ruling did say this could be done on an informed opt-out basis, which was a next step up from what had been talked about before, which was opt-in. But basically what the commission said there is, look, there's nothing in our rules, there's nothing in the Communications Act that actually prevents this being done on an opt-out basis, so you can go ahead and do it. It wasn't a new rule, it was an interpretation of what was already there. This specifically clarified that voice service providers could block calls informed opt-out basis based on reasonable analytics designed to identify unwanted calls. It also clarified that providers can offer blocking services that block calls not on a consumer's whitelist, which can, and this was sort of the key point of this, can be the consumer's phone contact list if the provider wants to offer that service and the consumer wants to opt into it. So I could say, I only want to receive calls from the 20 numbers on my contact list. No other call should ring my phone. The provider can offer that service. We then moved forward pretty rapidly to the July 2020 call blocking order, which adopted 2 safe harbors for call blocking. The first is a really clearly built on the 2019 declaratory ruling, and it protects voice service providers that block based on reasonable analytics and incorporate caller ID authentication information, such as stir shaken. That's the one type of caller ID authentication information that's currently acceptable. But the order does say that should the commission later say that other forms of caller ID authentication are appropriate, those would also be appropriate for use in the blocking programs. The analytics need to be designed to identify, again, unwanted calls, and the blocking must be done on an informed opt-out basis. So very similar to 2019 with the additional requirement of using that caller ID authentication information, but adding a little bit of liability protection just in case there is something that came up that could be a problem.
Which is a very significant thing for the industry to have that safe harbor.
Yes. The industry asked for it quite a lot. And so while the commission had said, we don't see anything in our rules to prevent this, there may be some sources. We want to make sure that you can go ahead and do this. This is important. The second safe harbor is a bit different. It provides protection that for providers that block all traffic from certain upstream bad actor providers. And bad actor providers in this context are providers that the commission has notified of illegal traffic on their network, and then the provider has either failed to effectively mitigate this traffic or failed to implement effective measures to prevent new or renewing customers from using the network to originate illegal calls. So it's very specifically about illegal traffic and about providers that seem to be facilitating illegal traffic, as opposed to just there's some illegal traffic that we aren't aware of. It does require commission notification, and the bad actor provider or the provider that has been notified needs to notify both the traceback consortium and the commission of the steps it has taken to effectively mitigate the traffic. And we do expect the downstream provider that's going to start blocking later to notify the bad actor before blocking calls. And then last but not least, we have that December 2020 order that just came out. Now, on the blocking front, there's one big piece there. And that is that order expanded the first safe harbor adopted back in July to include blocking of calls that are highly likely to be illegal. And again, illegal, not unwanted, based on reasonable analytics, which must include caller ID authentication information, without any consumer opt-in or out. So more narrow category of calls, but you don't need the consumer consent piece.
Okay, all right. And most of that is really designed towards identifying those things which are illegal or likely to be illegal, as you set forth the elements of it. Call analytics goes a little bit differently on that. And I know you mentioned call analytics a couple of times, and the commission has said that carriers should be using reasonable call analytics, and that has to support the blocking that is here. But the commission has taken kind of a pretty hands-off stance on what that is. Can you just describe very briefly sort of what the commission's approach is to reasonable call analytics?
Yeah, so you're right. The commission has taken a bit of a hands-off stance and repeatedly emphasized that flexibility here is important. And there's a risk in any sort of more prescriptive rules. The bad actors can just say, well, I'll just be 1 point under that threshold, or whatever that is, depending on what the rule happens to be. So reasonable analytics, the idea of reasonable analytics is to provide voice service providers with that necessary flexibility to respond to threats that are evolving and changing and approaches that are new and different. This is particularly true where we have the consumer consent piece, because then if the consumer finds I'm not getting calls I think I should be getting, then they can opt out of the blocking, and that is their prerogative. If they remain in the blocking, the assumption is they're at least reasonably happy with that. The one exception, of course, is that expansion that I was talking about in December 2020, which is not consumer consent based. That added some additional requirements, though, around it to make it a little bit more clear and focused on illegal calls, including actually a process prior to any blocking to confirm that the calls in that call pattern are highly likely to be illegal. Again, the key is these calls are highly likely to be illegal. And so while in a lot of the reasonable analytics cases, that consumer consent piece is very key, the goal here is narrowing in on only those things like no one wants to get an IRS scam call. Like, I don't know about anybody else, but I certainly have never wanted to get an IRS scam call.
Right, Jerusha. So I'm gonna listen. There is a lot to talk about.
Yes.
I think we got some questions already about some of the other aspects of the December 30th order, and we're going to try our best to get to everything.
Yep.
So let me try and just move you along just
Absolutely.
to speed us up here just a little bit. So one of the key elements of blocking was clarified in the December 30th order. Now the FCC is requiring that when a carrier or voice service provider engages in blocking, that it provide notice to the calling party. Can you just briefly walk us through what what is required there and how long providers are going to have to implement that notification?
Yeah. So really quickly, and if anyone has any more in detail questions, I'm happy to answer them. But basically, the December order requires the voice service provider to return specific SIP or ISIP codes when the call is blocked. These are network signaling codes that can be sent back to the point of origination. Specifically, SIP code 607 or 608 or ISIP code 21, though we did note that because ISIP code 21 already has other uses, it's possible a caller could receive SIP code 603 as well. So 603, 607, 608, ISIP 21, those are things for callers to keep an eye out for. Providers should be returning one of any of the three other than 603.
Right. Okay. So the goal is to standardize that. The
goal is to standardize and at least let a caller know, I should maybe look into this situation. As for timeline, the order sets the effective date as January 1st, 2022. So providers by January 1st, 2022 should have this implemented.
Okay, and presumably that notification will go through beginning earlier than that for many providers.
Right. I would suspect that there are probably providers that would like to just get it done, but they have until January 1st, 2022 before the commission starts to get concerned about it.
And then I have just one more question for you, and then we're going to jump to CJ to talk about stir shaken and the call authentication activities there. But at this point, sort of what evidence does the commission have about the extent to which these blocking options are being implemented and being utilized in anti-robocall tools?
Yeah, so other than things that are that have been provided, like in comments or ex partes in the various proceedings, the commission did release a call blocking report in June 2020. And that report indicates, based on the information we received, that major voice service providers in particular, offer at a minimum an opt-in blocking service, and some are already offering call blocking on an opt-out or default basis. Did clarify these services are very often offered in partnership with a third-party analytics company, so a lot of companies might just make a third-party service available to their customers and easily implementable. But as a couple examples, one major wireless provider indicated that since 2016, it had blocked nearly 1.3 billion suspected fraud calls, while 3 billion other calls were either blocked or labeled. And a major wireline VoIP provider indicated that it had blocked over 158 million calls just in December 2019 alone. So at least most of the big guys and some of the small guys have already implemented some subset of the blocking services that we've authorized, and they seem to be blocking a fair number of calls through it.
And hopefully that's, on the consumer side, that's making a difference and consumers perceive fewer robocalls.
That's definitely the hope, for sure.
Yeah. Okay. All right. So CJ, let's jump to the call authentication side of this. And that's something you guys have been working on pretty extensively. I think most of our group here knows what stir shaken is. It's sort of, in general, but I think it's worthwhile to talk about the goal of stir shaken and what it's really designed to do, because it's not a blocking technology like, the call blocking elements that Jerusha was just talking about. So what's really the goal in adopting call authentication here?
Sure. So STIR/SHAKEN is a set of technical standards and protocols that work to combat illegal spoofing by allowing a terminating provider to verify the caller ID information sent with the call matches the caller's number. So there's two kind of high-level components at play here. There's that technical process that allows for the authentication and verification of the caller ID information. And there's a second certificate governance process that maintains the trust and accountability among the providers that are participating. So I think it's helpful to think about STIR/SHAKEN, at least for me, in the context of the problem it's trying to solve, which is illegal spoofing. So as telecom industry expanded into IP telephony, consumers got a lot of benefits from the increased competition and decreased costs. But one of the effects of the increased competition is there's a lot more entities originating calls. So it's no longer a limited amount of carriers that can trust each other to provide the accurate caller ID. Those chains of trust have weakened because of the multitude of entities. So bad actors are having easier time targeting those weakened chains of trust between characters to use illegal spoofing to target consumers. So the idea behind STIR/SHAKEN is that it's creating the system where the caller ID information of a call can securely and safely be transmitted with the call itself from the originating provider to the terminating
provider. So you'll know as on the receiving end, you'll know that caller has a connection to that number, at least.
Right, yeah.
What if it's verified, right?
Yeah.
It doesn't, as a technical matter, stop spoofing, right? Like you can still send spoofed calls.
So it's correct. Yeah, I think the basic idea is that it's the originating provider sharing what it knows about the customer with the terminating provider.
Right. Okay. And it doesn't necessarily block a robocall or a legal call. It's still those calls can still go through. They will be verified in a different way, perhaps.
Correct. Yeah.
Right. Okay. All right. And so we got the first major deadline is this coming June. The commission has said that the largest carriers have to implement it in their IP portions of the network. But there are exceptions to that. And we already got a question about sort of like how much of the network are we expecting will be STIR/SHAKEN compliant by then? And I don't know if you're going to have numbers, but let's at least talk about the categories of calls where we're not likely to see implementation by June. What are we expecting there?
Sure. So as you note in the second report and order that the commission released in September, there's several categories of providers that received an extension to the June 30th deadline. The first is for small voice service providers. So the order defines that as a provider that has 100,000 or fewer subscriber lines. They receive a 2-year extension. The next kind of category of providers is those providers that can't obtain one of the certificates or tokens used by the governance authority to sign calls according to STIR/SHAKEN. They have an extension while they're incapable of qualifying under the governance authority policy. There's an extension for those providers that have a pending 214 discontinuance application at the time of the June 30th deadline. There's a 1-year extension that if the service is not discontinued in that year, then after that, the provider does have to implement STIR/SHAKEN. Because STIR/SHAKEN works on IP networks, there's a continuing extension for non-IP providers that have non-IP networks, and they have some more obligations they have to fulfill along with that. And the final piece is that in the second report and order, there is a mechanism for a provider by provider extension decision by the commission. And so those petitions were due November 20th. And the commission is currently evaluating those. And then the Wireline Bureau will release a public notice in March explaining its decision on those.
Okay. So there are going to be at least some pockets where we don't have STIR/SHAKEN implemented in that time frame.
Correct. Yeah. And I think in the second report and order, there's even those pockets that get the extension. There are still obligations for those providers to protect their consumers from illegal robocalls.
Right. Okay. So one question I wanted to ask you about was the situation where the service provider can't get a token. There has been a fairly significant change, and I'll make sure people are aware of it out there now, in the way the governance authority has addressed this question. For many providers, the question was, do you have access to numbers? Do you have direct access to numbers? But that's not necessarily going to be a gating mechanism anymore for having the token authority. Can you describe sort of what the commission is expecting on that front?
Sure. So yeah, commission staff talk regularly with Addis and the governance authority. So it was an issue that we were aware of. And as you know, in November, I believe the governance authority announced that a new policy will take effect once the commission's robocall mitigation database is stood up this spring. The commission released a public notice in November, and then I would encourage people to seek out the governance authority's website for a more complete description of what that policy will entail. But as I noted earlier, the commission in the second report and order did account for these providers that have difficulty qualifying for their certificate under the policy, and they will have an extension until they do qualify.
Right. Okay. And then I'm gonna come back and talk to you a little bit about the robocall mitigation plans in a minute, but I want to circle back to Jerusha now and talk about shifting back to the blocking world and the process now for dealing with call blocking. We talked about what was going to be involved in call blocking, what is permissible, the call analytics. At the same time, right, those who are originating calls are very concerned that their calls will be misclassified, and some of them will be blocked. They will have this notification coming eventually. But the commission, most recently in December, did talk a lot more about the redress process and what would happen for claims of improper blocking of numbers and calls. So can you walk through sort of what the requirements are there for the industry, both what the calling provider should expect, but also what the industry needs to have in place?
Yeah. So the December 30 order did a few things on transparency and redress. The immediate notification, as we already discussed, is a really big one. There's also some transparency for consumers regarding lists of calls blocked on an opt-in or opt-out basis. And then there is, in July, we made clear that voice service providers needed to have a single point of contact publicly available on their public-facing website for callers to dispute call blocking or what they think is call blocking. That requirement didn't have any sort of set timelines associated with it. It was just like, you have to be ready to take these complaints and deal with them. We've now modified that slightly to say you need to actually at least give a status update within 24 hours. Status update does not necessarily have to be a resolution, though a resolution would quite obviously be a status update. And the reason for that is that while callers expressed legitimate concerns that their issues weren't being handled and they weren't getting resolution, voice service providers also expressed legitimate concerns that sometimes these things take a while. I believe there was at least one or two comments that talked specifically about the caller not getting back to the voice service provider when the voice service provider asked questions. So the 24-hour status update is a bit of a balance of those concerns. Of course, the commission does require that these be resolved in a reasonable amount of time. So if resolution is completely unreasonable, if it's taking a year to resolve, that'll take the extreme, because a year would be, there's no reasonable situation in which it would take a year. But reasonable is going to vary on a case-by-case basis. But if it is truly unreasonable, then the provider is not meeting that requirement. Also in there is the requirement that this point of contact also handle inquiries from callers that are adversely affected by information provided by the caller ID authentication frameworks. So what CJ was just talking about. So the terminating provider also has to be prepared to handle those kinds of questions and concerns. The commission did note that, yeah, we recognize that the terminating provider isn't the one that signs the call. However, the originating provider doesn't have any power to ensure that the terminating provider gets the signature. So we had to pick one. And since the terminating provider is already the one handling call blocking disputes, seemed reasonable to have them handle the authenticity disputes. Also, if they're being adversely affected, it's probably by action that the terminating provider is taking. So maybe they can't get attestation fixed, but they can use that to change the action being taken.
Okay, yeah. So the goal is to ensure that there's communication between parties.
Yeah, we want this to be more of a dialogue than a hey, I have a problem, black box until resolution comes.
Right, and I think there's a lot of common ground in the goal, that is, to make sure that blocking is done correctly and only blocks the things that consumers don't want to receive that are illegal, and allows through the things which are potentially meaningful or helpful to the consumer. So I think there's a lot of common ground there. That doesn't make resolution easy by any means.
Yeah, no, and the commission has said that, we believe voice service providers have every incentive to make sure consumers get the calls they actually want, because those are their customers. So.
Okay, so let's just clarify on this though. So those are the rules relating to blocking. Mm-hmm. There is a process, a redress process for labeling of calls as well. That is calls which are sent through, but with a descriptor to be helpful to the end user. Mm-hmm. These rules don't apply to the labeling activities of this.
No, generally they would not apply to labeling. It's possible that the adversely affected by caller ID authentication may have some play in labeling. Depends on how voice service providers are determining those labels and how they're using call authentication in there. But that's sort of the outside case, not the main case. The commission did note in December that labeling and blocking aren't really equivalent. A consumer may decline to answer a call that's labeled because it's labeled scam risk or spam risk or whatever the label happens to be. I got one earlier that said account services, and I have no idea why any account services would be calling me, so I didn't answer it. Also, they've called multiple times and hung up when I did answer. So I assume they're not someone I want to talk to. But in those cases, a labeled call rings the phone and the caller can leave a voicemail or use any other means to contact the consumer that they would have in any situation where the consumer declined a call in general. Whereas in blocking, the consumer's phone never rings. They may or may not get a voicemail. They may or may not have those options. So labeling and blocking have some differences there. The commission has said that, they do encourage voice service providers to work in good faith with callers to ensure that labels are accurate, because that allows the consumer to better use the label to help determine whether or not they want to answer the call. So while the redress requirements do not apply to labeling, the commission definitely does encourage providers to work with callers on labeling.
Okay, great. All right, so we've got just a few more minutes here, and I'm going to get to CJ to talk about robocall mitigation programs. But Jerusha, we did get a question, and I think it's in your area. I apologize ahead of time because I get your areas confused often myself.
Well, and it's the Trace Act one, right?
Yeah, the Trace Act has imposed a lot of obligations.
Yeah, and the Trace Act is all over the commission. So the Know Your Customer parts of the Trace Act, I would have to look at more closely to really give you any information about how those are being handled, or if I know how those are being handled. I don't have a specific update right now on that. I do know that there was some Know Your Customer stuff in the One Ring scam proceeding, and the December call blocking order did adopt some requirements that are sort of know your customer-ish, but they weren't adopted in response to the Traced Act. So I'm not sure what the current status of that is.
Right, right. Okay, okay. Well, and we'll go that, and I think gonna have some time to talk about it in the industry panel as well. Some of that is related to, CJ's coming to you now, right? The idea that originating carriers should do what they can to prevent and avoid illegal robocalls. So, on that front, one big element of that is these robocall mitigation plans. And as I understand it, with the commission's orders, if you are subject to one of the exemptions for any reason, then carriers will eventually be filing a notice of that. And with that, will also file a robocall mitigation plan describing what they are doing for those portions where they haven't implemented stir shaken, and what they're doing to prevent and avoid the origination of robocalls. So can you walk through sort of what those requirements are? Like what has the commission said about what needs to be in a mitigation program?
Sure. Yeah, and as you point out, the robocall mitigation programs apply to those providers that have an extension from our June 30, 2021 stir shaken implementation deadline. The idea being that the provider is either instituting stir shaken or robocall mitigation program to protect its subscribers. So in creating the rules around the robocall mitigation program, the commission has a general standard. It's a non-prescriptive approach. So there's a general standard with one prescriptive element that's necessary but not sufficient on its own, with the idea being that providers should adopt the program that best suits their network. So the general standard is that the robocall mitigation program should reasonably be expected to significantly reduce the origination of illegal robocalls. So a provider should comply with the elements in its program that it submits, and the commission will find a program insufficient if the provider is still knowingly or negligently originating robocalls. Different types of providers should have different programs because their networks are different, and the commission wants providers to take innovative approaches that really are adapted to their networks. The one prescriptive requirement is participation in industry traceback, which the commission thinks is very important in the absence of stir shaken. So that's a necessary part, but not sufficient on its own.
Okay, so if you're a provider who, say, for example, doesn't offer the capability to initiate high volume calls, you might have a very different mitigation program than one who serves the call center business.
Yeah, your program should be adapted to your network. Yeah.
Right, right. Okay. And we haven't yet set a deadline for filing those plans, right?
Correct. So yeah, the commission will issue a public notice no earlier than March 30th. That's announced kind of more of these requirements of submitting the plans, and the deadline will be no earlier than June 30th, 2021.
Okay, so it is coming. So
yeah.
Good time to start planning if you're a service provider.
Absolutely.
Right, right. Okay. All right. Well, listen, this is great. I got sort of maybe one more time on this. So let me come back to where I started with this multi-prong approach. The commission looking at multiple things. I just want to get your idea at this point. How would you evaluate that so far? Are we seeing benefits on this robocall front at this point?
Do you want me to go first?
Either way.
Jerusha, you can go.
I mean, I would say that it's a little hard to evaluate because, for example, the stir shaken implementation deadline hasn't been reached yet. So there's a lot of pieces that just aren't necessarily in place. I do think that the commission has emphasized over and over again that it has to be a multi-pronged approach, that there's no silver bullet to this. These bad actors, they adapt and they change and they shift, and you close one door and they find a little hole somewhere to crawl through. So you know, it is a little bit of that, but I do think that the multi-pronged approach is essential, and I think that hopefully once some of those pieces are in place, such as stir shaken, such as some of the stuff in the December order that is not yet effective, I really do hope that when we get there, that we will see some really good progress.
Okay.
Yeah, I agree. I mean, on the call authentication front, stir shaken is a vital tool. And this June 30th deadline is the culmination of several years of hard work from the industry. And so we're very excited for it to come and to get on the other side of it and to have stir shaken more widely adopted. There's more work to be done to ensure that deployment is ubiquitous, and also to fine tune how exactly providers are using that information. But it's absolutely a significant step in the right direction to really stop some of the worst kinds of robocalls.
Great.
And I do think, really quickly want to say, they all feed into each other too. So stir shaken feeds into call blocking. It also feeds into it also can feed into enforcement, you know, so all of these elements of the approach really have to work together. And that's why I say, you know, some of these aren't fully in place yet, or have only been in place for a very short time. So it's kind of hard to assess the actual.
It's a real puzzle. And listen, for walking us through the many things that have been implemented so far, and through the very complex rules that are there. I thank you both for your time and for your efforts in trying to restore confidence again in the voice calling system. So thank you all very much. Thank you for joining us. Those who are members, attendees of the INCOMPAS Policy Summit, we are going to move to our next panel, which is our industry panel. We will have to do that, however, by logging into the next session. So we're going to end this session. Everyone will need to log into the next session. I will be back then with another set of panelists. So thank you all for joining INCOMPAS. Thank you guys for joining us, and have a good day.
Thank you.